I've been getting bombarded with requests from people who want to talk about what's going on with Senate Bill 140. So what I would like to do today is dive in and figure out what all this is and what it means for you. Senate Bill 140 is Texas's new law that expands our existing telephone solicitation regulations. Now, if you're an email marketer or you're sending SMS messages, don't let your eyes glaze over at this. I'll tell you what you need to know here. This law was designed to do three things. So what they were doing with Senate Bill 140 was trying to, number one, expand some protections that we already had concerning telephone solicitation and things that are solicited over your phone. They wanted to clean up some parts of the law that were a little bit messy and then take advantage of a Supreme Court decision that narrowed some federal protections. So that last part, why don't we just start with it? Because this is where things get a little interesting. Back in April of 2021, the Supreme Court decided Facebook versus DeGood. This was really a huge case that fundamentally changed a lot of telecommunication law, where it is surrounded by issues dealing with the Telephone Consumer Protection Act. So let's back up for a second and explain what the Telephone Consumer Protection Act is. It's most broadly known as the TCPA. It's a federal law from 1991, and best known historically for restricting junk faxes. Not much of a problem anymore because unless you're like a medical doctor or some attorneys still, you don't see a lot of faxes in you. And so there aren't a lot of junk faxes that eat up paper and toner on your printer. But in addition to that, it also covered auto-dialed calls to cell phones, pre-recorded voice messages, and text messages to wireless numbers, and then also calls to people who put themselves on the National Do Not Call Registry. For years and years and years, there was this kind of robust body of law that defined what an auto dialer is under the TCPA. And basically what they said was, if it is something that takes a list of numbers, no matter how it's generated, and dials those, then that would be an auto dialer. But the Supreme Court looked at it back in 2021 and said, no, we're going to narrow this. And so they held that to qualify as an automatic telephone dialing system, equipment has to use a random or sequential number generator. So it's not enough that you give it a list and it picks from that list at random. It has to actually generate the numbers. Whether that's done in random or they start with 000, 001, and then to 2 and 3 and so forth. So whether it's done randomly or in sequence, didn't really matter. What the Supreme Court basically said was that the dialing system has to generate the numbers. In most modern texting platforms, they don't do that. They use stored lists. And so suddenly a huge chunk of text messaging fell outside of federal TCPA protection. Now, when something like that happens, especially with a law like the TCPA, where it actually explicitly says, if you as a state don't like what we're doing, you can pass your own law that is more strict than this. So the TCPA sets a floor, but not a ceiling, and states are allowed to say, in this instance, we like the way that things were, and we're going to provide more protection than the federal law requires. And that's exactly what Texas was trying to do with Senate Bill 140. So let's have a quick look at Senate Bill 140. It's a really short bill. What you're looking at here on your screen is the entirety of the bill. The only other thing that you would see on another page is signatures from the House and the Senate and clerks and the governor. So this is the entirety of SB140. What you should notice when you look at this is that it doesn't do a whole lot. You see a section where we have telephone call being called out as a new definition. That's what the underlining means. Then we also have telephone solicitation being redefined. And that redefinition comes by subtracting the word telephone and then adding some more text and then removing the word initiates because we put that in another place in the text. And then we have some more sections down in here where it says if you've recovered once, that doesn't mean you can't recover again in the future if someone breaks the law multiple times. And then finally at the bottom, it says this is something that falls under the ambit of our Deceptive Trade Practices Act. And again, it says if you've recovered once and they break the law again, you can recover a second time. So what changed as far as what we're wanting to talk about here? Well, it's that definition of telephone solicitation. So first we have the old text. Telephone solicitation has the meaning that is assigned to it by section 3.0 or 304.002. And that explicitly ties the concept of a telephone call to what's in chapter 304. So we go over there and have a look. And in that chapter, there are a number of exemptions for consented communications. But then they also expanded the definition of telephone solicitation. The old definition, what you see on the screen, said a telephone call that a seller or a salesperson initiates. The new one says it is a call or other transmission, including a transmission of a text or graphic image or graphic message or of an image initiated by a seller or salesperson. So you see what they did there? Inside the definition, they changed telephone call to just call or other transmission, and then added some explicit language about texts and images. Throughout the rest of the build, they added some language that dealt with protecting not just people, but also the public. In other words, this is not just intended as a law to protect individual people. This is intended to be done in order to protect the general public at large. There were some sections that you see where what they said was, this protects the public, and others where it says, this protects people. And so what you see is some cleanup in language so that those sections now actually say the same thing. They also added this other bit that I've mentioned a couple of times already that says if someone violates the law and has to pay you because you sued them under the private right of action that is allowed under the telephone sections dealing with the Deceptive Trade Practices Act and other parts. So they have to pay you as a result of that. They can't come back later if they break the law again and say, whoa, we already paid once. They're going to have to pay again. And of course, we see that explicit tie to the Deceptive Trade Practices Act, which is really kind of important because that's one of those laws where you can get attorney's fees, which means you can actually have, in addition to anything else that they have to pay, you can have them pay for your lawyer to sue them. Now, before Senate Bill 140, if someone violated Chapter 304, there were some administrative enforcement things that would have to happen. But these new sections now say that it's a false, misleading, or deceptive act or practice under Subchapter E of Chapter 17. That's the Deceptive Trade Practices Act. Practically, what it means is that consumers can directly sue under the DTPA without having to do anything with the state first. They can get some extra damages if they can prove actual damages, and they can recover attorney's fees. And that makes it more likely for plaintiffs' lawyers to take these cases on contingency. And there's no cap on how many times you can sue someone. Or, if you're watching this as a marketer, there's no cap on the number of times that one person can sue you for violations of this law. Now, there are some things, and if you get sued, your attorney will talk to you about how those things might impact this. If they've got a number of things, they will probably need not to have a separate lawsuit for each time they think that you violated the law. But when you settle that lawsuit and you take care of everything before today, and then you go out tomorrow and break the law, they can sue you again day after tomorrow for breaking the law tomorrow. So what happened? We now have a law that was passed that was intended to clean some things up, expand some protections in response to a Supreme Court case that narrowed protections. So Texas is trying to sort of expand things back out to where they were. And then sort of clean up some language and do some other things. Now on September the 1st, literally the day that the law took effect, a group called the Ecommerce Marketers Association filed a lawsuit. That lawsuit came in and said a number of things. So they filed this lawsuit in federal court trying to block the law, and their argument was essentially this law is unconstitutionally vague and we can't figure out what we're allowed to do. We can't tell if the law applies to us. And we want you to tell the state they can't enforce this thing. And you'll notice that there is a request for injunctive relief, and they actually asked for a preliminary injunction, which basically says tell the state they can't enforce this while the lawsuit is pending. They make several arguments. One of those is vagueness. We don't know what we can do. Second, they say this is an unconstitutional burden on our commercial speech. And commercial speech is a thing. And then 3, statutory interpretation. This bill is so confusing that key exemptions that used to apply may not apply anymore. We just can't tell how to interpret the statute, especially in relation to the things that we're doing. So let's have a look at some of what's going on here. So we have this motion for a preliminary injunction, and it says a number of things. It says that there's a problem with vagueness. It only applies if, quote, the purchaser is located in the state, unquote, according to the filing. But how do you know where a purchaser is located? And that's a good question. Phone numbers are portable. FCC regulations, in fact, say that a carrier can't tell someone where a customer is located without consent. So you can't just call up the phone number or call up the phone company and say, I've got this number, or tell me where they're located. And you can't rely on area codes. I could have a 512 number from Austin, that's their area code, but I could live in California. I'm in California. I've got one of their area codes, and I get transferred to Austin. Now I'm in Austin, live in Austin. I'm a Texas resident, but I've got a area code that belongs to California. But the law requires that you know something that you can't determine based upon that phone number. Second, what's a retail establishment? There are some exemptions that happen for retail establishments, but it doesn't really define what that means, at least according to the lawsuit. A kiosk in a mall, a retail establishment. The example that they use, what if I only have an online business? Am I covered as a retail establishment or not? If the only thing that is covered is going to be people with bricks and mortar locations, then I have no way of knowing that when I've only got an online business. And then also, what's a former customer? There are some exemptions for solicitations of current or former customers, but is it really defined? And then fourth, when has a business relationship been terminated? the establishment of business relationship is something that you can more or less nail down, but when is it terminated? When I want to be terminated? When a certain period of time has, so bought them 15 years ago, are they still a former customer? There are some times that are dual. Is it something where we've transacted business within the last year, or I told you explicitly that I want to do business with you anymore, and it had a year. It's in fact one of the things that's in part of the telephone law. So you have to do it in writing, to have relatively opt or does friendship terminate automatically after some period of inactivity? They aren't really hypothetical questions. They're real compliance things that marketers are going to need answers to, and the statute doesn't operate them. The Ecommerce Marketers Alliance says this is something we know what to do. They also said that the old definition said that we're dealing with a telephone call that a seller initiates. But the new definition says call or other transmission. A telephone call to just call, according to the plaintiffs. The legislature makely severed the link between Chapter 304's exemptions and what we see with the stuff going on in this other chapter. So even the bill adds cross-reference saying telephone call means what Chapter 304 says it means. That may not help because the actual definition gives some different language. The result, according to the plaintiffs, even to the text messages might not be clear. Now, the Attorney General has filed a response. They did this back in September on the 26th. And as a result of that, we have seen some folks taking a victory lap. Their response basically says, you're already, these plaintiffs face zero injury here because they're already exempt from the law. They said text with consent, and those are exempt. As far as we're concerned, case closed. It was obviously a telephone call. The legislature even added Section 302, 6A, that explicitly says a telephone call means what Chapter 304 says it means. And if you look at what a telephone call means under 304, it explicitly has agreed to. In other words, if it's consent, it's not. And so you see the response. What the AG said in its response document is, boiled down, this case turns on whether the word call as it appears in Senate Bill 140 means a telephone call as defined by Chapter 304. If the answer is yes, the state argues, then plaintiff's conduct is not even reached by Senate Bill 140 and their alleged injury came from. And then they go on to give three reasons, but just notice the first one here, and all that I put was the caption over it. The ordinary meaning of a call, as it is used in Senate Bill 140, is a telephone call. Let's have a look at what this means. In Chapter 304.0210, we see the definition of a telephone call, but it carves out specific. It doesn't, for instance, include a transmission where the customer is agreed in advance expressly or impliedly to receive. So that's the consent exemption. But there are other exemptions. Chapter 304.04 says the entire chapter doesn't apply to calls that are made in connection with an existing debt or contract. It also doesn't apply to calls in connection with an established business relationship. But what's an established business relationship? Well, that's defined as a relationship between a telemarketer and a consumer based on the consumer's purchase, rental, or lease of goods or services from, or financial transaction between the consumer and the telemarketer within the 18 months immediately preceding the date of the telemarketing call. It also includes voluntary two-way communication that hasn't been terminated by either party. Then in Chapter 305, where we see something that specifically addresses calls to mobile phones. Chapter 305.01 prohibits calls to mobile phones for which the called person is charged, but it has an exemption. It doesn't apply if the called person has previously consented to the making of such a call. So when the AG comes in and says consented communications are exempt, they're not making it up. These exemptions exist throughout the statutory scheme. The question is whether these changes that SB140 made accidentally severed that connection so that what we see with those exemptions are no longer at play. So the AG, in their response, is stating that their office interprets the law to include those exemptions, and they have no intention of going after anyone sending consented text messages. I might lose some of you here, but I ask you to hang with me for a moment. A lot of folks in the industry are acting on the basis of this filing by the AG like they've already won the lawsuit, taking victory laps. But let's pump the brakes here for a second because there are some problems with declaring victory right now. First of all, this isn't a final ruling. We have a preliminary motion and a response. That's it. No judge has ruled on anything yet. So we don't know what the judge thinks. If this were to go to trial, we don't have a final judgment. We have a request, and then we have someone responding to that request by saying, you don't need to honor that request because here's what we're thinking. Second, jurisdiction matters a lot. This lawsuit is in federal court, which means we're asking a federal judge to interpret Texas state law. But the ultimate authority on what Texas law means is not the U.S. Supreme Court, it's the Texas Supreme Court. So what we have here is an area where we're asking a federal judge to have a look at a law and then take a guess, basically, an educated guess, but a guess, as to how Texas courts will interpret this Texas law. In my opinion, that's not the cleanest way to resolve this. I probably would have preferred to see this case filed in Travis County's state district courts first. Then you get the Texas courts to definitively say what the law means. Then you can challenge whether that interpretation violates the First Amendment. In my opinion, that's a cleaner way to go about things. So you go through, you get something from the Texas Supreme Court that says this is how this law should be interpreted. If this organization feels like that continues to violate their First Amendment rights, they can appeal that decision over in the federal court system. And then take that to the Supreme Court and get the Supreme Court to weigh in on whether or not basically the Texas Supreme Court got it right. But third, the AG's interpretation here isn't binding on anyone. What we have here in this response is the Attorney General's statement about how they, at least at this particular moment, think they'll enforce the law. And that statement's great. It's meaningful, it's reassuring, but it's not a court ruling, and it's just an argument in a brief. It doesn't even legally bind this Attorney General or future Attorneys General to a particular position. In other words, tomorrow, Ken Paxton, the current Texas Attorney General, could say, I had it wrong, I made a mistake. There's more than one way to interpret this, and I want to interpret it the other way. That doesn't mean, or this filing doesn't mean that Mr. Paxton can't do that. So this statement that we have within this filing isn't even binding on this Attorney General. It's not binding on other Attorneys General who will come after him. Or, and this is significant, it's also not binding on any of the private plaintiffs who have their own right to sue under this law. The Attorney General's interpretation of how a telephone call is what is meant by a call isn't binding on trial courts across Texas or any other state officials. Now, do I think this is the proper direction? Yeah, I think the Attorney General's position here is pretty reliable. And I think that if they were to change it, it would create some credibility issues. But what they say here in this response to a very preliminary motion, a motion for basically a temporary injunction, isn't binding. It's not binding on what happens in the rest of the case. It's not binding on anything. It's just what they said in one of their very first responses to anything in this case. And then fourth, I would point out that the statute has more than just call in it. The AG argues that call means a telephone call, and then that's fine, but the statute also says or other transmission. And if I were a plaintiff's lawyer looking to sue someone under SB140, I wouldn't even argue about what call means. I'd focus on other transmission. Is a text message another transmission? Pretty hard, in my opinion, to argue that it isn't. So even if the AG wins the call means a telephone call, argument, there's still statutory language that could cover text. And if you think folks won't try to do something like that, I just need to point you in the last few years over to the state of Arizona, where plaintiffs' lawyers took a law that dealt with the need to get consent to do some things and sued a number of folks in state and federal courts over what an Arizona law said. Those cases have mainly gone away, but is there some legal risk there? I think there is. So even if the AG wins is a telephone call argument, there's still statutory language that can cover text messages. So there's the legal theory. Enough with the legal theory. What does this actually mean for us? Well, number one, based on the Attorney General's response, I think we have a pretty clear signal. If you're sending text messages with consent, the state of Texas doesn't intend to prosecute you. That should help you sleep a little better at night. It's a meaningful statement, and to some degree, I think it matters. But the law also intentionally allows private individuals to act as what are sometimes referred to as private attorneys general. That is, there's a private right of action in there. The Attorney General is not the only person who can sue under the law. And some lawyers do love to push those boundaries. So they may go after marketers who didn't register. Most people would just post a bond that's kind of almost like car insurance. You can get the $10,000 bond pretty cheap. And then didn't comply with other technical requirements, even if the messages were consented in some instances, perhaps. So let's look at some of those requirements. If you're a telephone solicitor under Chapter 302, the Texas Business and Commerce Code, you have to register with the Texas Secretary of State. That registration costs $200. You also have to post a bond or irrevocable letter of credit in the amount of $10,000. And the bond has to be issued by a surety authorized to do business in Texas. And it has to run to the state for the benefit of persons who are injured by violations of the law. You also have to maintain records of all your telephone solicitations and provide specific disclosures during calls. You're expected to do not call requests immediately, and if you use a fictitious business name, you have to disclose your true legal name. Well, here's kind of the question that nobody, I think, can answer definitively right now. If you're just sending text messages with consent, are you actually a telephone solicitor who has to do all this? The Attorney General's position, at least as it is voiced in their response to this motion for a preliminary injunction suggests that the answer is no. Consented communications are exempt. But until there's a court ruling or formal guidance, I think you've got some technical compliance requirements on the books that could theoretically apply. And that matters because even if you have consent, if you're not doing anything wrong substantively, someone could still sue you for failing to register a post bond. Lawsuit might not succeed, but defending the lawsuit costs money, and that's the risk you have to take. As for the private right of action, what can you actually get sued for? What are the damages under Chapter 302? Follow the TCPA. They result in civil penalties of up to $500 per violation, but you can actually recover actual damages if you can figure out what those damages are. And if the violation was committed knowingly, the court can award up to 3 times actual damages, plus attorney's fees, plus court costs. So, what are actual damages? In an unwanted text message case, honestly, probably not much. Why? Because we have a state of affairs these days where most people don't pay by the text message. So those are probably nominal damages. But when you multiply that by hundreds or thousands of recipients and then potentially multiply that by 3 and add in some attorney's fees at $200 to $500 an hour, you can see how this becomes expensive pretty quickly. And that's assuming that a court finds that the damages are truly nominal. Especially if you're also dealing with a TCPA violation, now you've got damages in the range of $500 to $1,500 per text. And the real exposure isn't from one lawsuit from one person. It's a bunch of lawsuits from a bunch of people. It is potentially class action litigation. So, those are all things to take into consideration. And area codes, we've already said, don't equal location. You can look at area codes and decide someone is or isn't in Texas, right? Well, no, I've got a Texas area code, but again, if I move to Nebraska, guess what? I'm keeping my number. If I lived in Nebraska and I was coming to Texas, I'd probably keep my number even there. So location-based compliance on what the area code of a phone number is really, really difficult to do. As a result of all this, the statute is a little bit unsettled. Until we can get a final ruling from an appellate court, or better yet, the Texas Supreme Court, there's legal uncertainty. The problem with getting a final ruling from an appellate court or the Supreme Court is it takes a lot to get there. And one of the things that I have advised clients on for the last 10 years or more, when it comes to something like this, is do you want to fund the lawsuit? And the answer invariably there is no. Nobody wants to fund the lawsuit. Who wants to pay to get that ruling from an appellate court or the Texas Supreme Court? The answer is nobody. So, let's start on how to move past this. We've got guidance from the Texas Attorney General that says if you're sending messages with consent, then those aren't really reached by this law. So what does consent mean? First of all, I'd say that consent needs to be real consent. Don't get cute with what consent is constituted by. If you're relying on a consent exception, make sure you actually have clear documented consent. Here's some practical guidance. First, consent should be clear and conspicuous. That's the first thing. Clear and conspicuous. It shouldn't be buried in fine print at the bottom of your terms of service page that you know nobody reads. In my opinion, it should be a separate affirmative action. A checkbox, a button, a text to join message, something that shows that this person understood that they were agreeing to receive messages. Second, it should be specific. I agree to receive marketing messages from company X is better than I agree to the terms and conditions of this website. General agreeing to terms isn't the same thing as specific consent to marketing communications. Third, consent should include disclosure of what they're consenting to. They should know that they'll receive marketing. They should know that the message will be you. They should know that they opt out. So by checking this box, you agree to receive marketing communications from message data rates may vary. Reply stop to opt out. Believe it or not, much of that language is already required just to get your foot in the game. That's what carriers want to see to deliver your message. Well, document everything. You want to keep records of when intent was obtained, how it was obtained, and what the person saw when it can. If someone clicks on your website, you want to save a screenshot of what that page looked like. If someone texts a keyword to opt in, keep records of messages. If you ever get sued, you'll need to prove that you consent. Fifth, I would say that you need to honor opt-outs immediately. If someone texts stop or unsubscribe or asks to be removed, if they call the front desk at your day, I want off your list, have a way to remove them immediately. Send just one more message. It is TCP level express written consent, necessarily. The TCP errors create specific consent for automated calls using an auto to include written consent to the phone number, signature, some specifics. We all do that level here, the extent of the consent, but my advice, if you want to sleep soundly at night, that level anyway. It's about consider people seeing it because even though the Supreme Court narrowed it down to give me one, there was like 30 years where you had to get the TCP consent anyway, which means it's really defensive. At a minimum, make sure your consent is only voluntary. Make sure you can prove it. Make sure you honor it when people opt out. So here's my practical advice. Proceed with caution. If you're buying lists of random numbers to blast, don't. Just don't. That's the worst case scenario under this law. If you're texting people who didn't sign up, the Texas Attorney General said in this filing, this doesn't count if you're sending messages with consent. What he didn't say is this doesn't count if you're sending messages. So if you're out there buying lists of messages and you're not getting consent, understand this law means the Texas Attorney General, all of those people that you're sending messages to in Texas, can come after you. That's the worst case scenario. Document that consent thoroughly. If you're somewhere in the middle, talk to a lawyer about your specific situation. I know that's not satisfying, but it depends really is often the most honest legal answer. And then consider your risk tolerance. Some marketers are still avoiding Texas texts entirely. Speaking as someone who is in Texas, I feel like that might be overly cautious, but I understand. Others are proceeding normally with consented communications. That's probably fine too, though there is still going to be some residual risk. Now, on October the 6th, both parties filed a joint motion for an extension on when they file their responses to each other on things. It's not on the page that I put on the screen here, but we have this joint motion to extend deadlines. And on the top of the next page, it says that they're engaged in discussions regarding resolution of this matter. Based on how these discussions progress, we're likely to see the plaintiffs voluntarily dismiss the case. And that's what I think will happen next. What does that mean legally? Nothing. A voluntary dismissal doesn't create precedent. It doesn't bind anyone. It doesn't establish how the law should be interpreted. The statute remains exactly as ambiguous as it was before the lawsuit was filed. Here's what we'll still have. We'll have this reply in opposition to the plaintiff's motion for a temporary injunction, in which the AG states a position that isn't binding on an unclear statute with competing reasonable interpretations. You still have private plaintiffs who can sue under the law, and you still don't have official guidance or a court ruling. In other words, if the case is dismissed without formal AG guidance or a settlement agreement that has substantive terms, we're back where we were on September the 1st. And the lawsuit will really accomplish nothing except generating some billable hours and some blog posts and, hey, a video like mine. So what should you do? Well, I've already told you, proceed with caution. Get real consent, document it, don't buy lists, and understand that without a court ruling or something from the AG in writing that says this is our official guidance, I think legal uncertainty remains. So here's the bottom line. SB140 expanded state telemarketing laws to explicitly cover text messages and other digital communications. The AG in a filing said that consented communications are exempt, and that's a meaningful signal, I think, about how the AG intends to enforce on his part. So you've got a lawsuit that challenged the law, but it looked like it's going to be dismissed, which means there's no court ruling, and we are where we were on September the 1st. The safest approach, if you want to send text messages to people in Texas, is to use consent-based marketing with clear documentation. Will there still be some risk? Yes, especially from private plaintiffs, until we get some definitive court rulings. I would say don't panic, but don't ignore things either. And I know this is frustrating. You want a simple answer to, can I text people in Texas? But the honest answer is it really depends on your specific facts, your risk tolerance, and how courts will ultimately interpret the law. What I can tell you is that if you're sending marketing texts to people who signed up to get them, and you can prove they signed up to get them, you're probably in pretty good shape based on everything we know right now. If for no other reason, people who know what they're getting into, you have documented proof that they did, those folks are probably way less likely to complain or go find an attorney to sue someone. But if you're doing anything sketchier than that, you should talk to a lawyer, preferably one who's licensed in Texas and understands this law. If you're waiting for absolute certainty before you make any decisions, guess what? You're going to be waiting a while, because that's not how things work. We get clarity over time in court decisions and enforcement actions, and those things take time. We're at the beginning of that process, not the end. And I can't give you specific legal advice without becoming your lawyer and understanding your situation. I do hope, though, that this helps you understand what's actually going on with SB140, what the lawsuit means, and how you should think about your own risk. Stay smart, and for goodness sake, get real consent. You will never hear me tell you that getting consent is a bad thing. So get consent before you text people. That's good advice, whether Texas has a special law about it or not. So, I'm Mickey Chandler. I'm an attorney, but I'm not your attorney. This is intended to be educational information on general legal ideas concerning one law, not legal advice, and you should consult with qualified legal counsel about your specific situations. If you have questions you think I can answer, understanding that I am not your attorney and you shouldn't be giving me anything you don't want out there, leave it in the comments. And let's see where things go from here.